So we are now going to understand about the contract. Contract refers to offer plus acceptance plus legal enforceability. So first we need to understand what is an offer. Offer is a thing like somebody is giving you some kind of a favor or a kind of offer for doing something that can be termed as an offer. Example for this can be you visiting a shopping mall wherein goods are displayed and you can understand that we need to purchase them. So that can be a formal offer given. Then we will understand what is an acceptance. Acceptance refer to a customer preferring to buy it. And that too, suppose there is any default in case we are not able to take the goods or if they are in defective form, then we can directly sue by visiting the consumer or customer forum, right? So that is how offer plus acceptance plus legal enforceability, these are the three main things which constitute the law of contract that can be termed as in contract and which makes agreement and offer separate. Agreement versus contract. That is the difference between the agreement and contract. So in agreement also we have this offer and acceptance with us, but in contract, offer, acceptance and legal enforceability. These are the three things which are essential for any agreement to become the contract. There is a very famous statement when you come to law of contract that all agreements are not contracts, but all contracts are agreements. Because without agreement, there cannot be any contract. So that is how we say all agreements are not contracts, but all contracts are agreements. This is how we can say it. So now, moving on to the next slide, we will go to what will this presentation include. This presentation will provide you an in-depth exploration of the law of contract, focusing on key concepts such as definition, essential elements, legal framework, governing contractual agreements. We will examine the critical components that constitute a valid contract, including offer, acceptance, consideration, capacity, as well as the implication and breaches of quasi contracts. So these are some things which we will be moving forward when we are explaining about law of contract. It is a comprehensive inclusion of all the elements which I have mentioned here. So coming to the next one. So as I said you, law of contract we are going to start. So we should understand what are the essential elements of a valid contract. In that, first one is the offer, second one being the acceptance, third one being the consideration, fourth one being the lawful object, fifth one being the capacity to contract, sixth one the free consent, and the seventh one being competency to contract. So these are some essential elements whenever you are willing to go into a contract with anybody. As we know, offer is the minimum or the first step in any valid contract. Second one is the acceptance. Third one is the consideration. That means it should involve something in exchange. Then the fourth one is the lawful object. Fifth one is capacity to contract. Sixth one is the free consent. And seventh one is competency to contract. So coming to the next slide. So, definition of contract, will move to the definition of contract, wherein a contract is a legally binding agreement between two or more parties. As I said you, any contract is not possible without two parties involved. It is enforceable by law. Anytime any of the essential features of the contract is not fulfilled, then it is directly enforceable by the court of law. It requires mutual consent. Both the parties should accept each and other terms, then only a contract is possible, which forms the basis of obligations and rights arising from the agreement. So, the basis of obligations means any contract will involve certain duties, certain rights, etc. Those has to be fulfilled in order to complete the agreement which is there arising out of a particular contract. So first, any contract will be in agreement stage. Then, if it becomes lawfully considerate or legally enforceable, then only it can become into a contract. So the primary stage we can say is an agreement, and after that, adding to which, if there is anything like the legal enforceability, then it becomes the contract. Now moving on to the next slide, we will understand what is definition of agreement, because as I said you, any agreement after it becomes legally enforceable, then only it can be termed as a contract. So first we need to understand what is an agreement. So agreement is a mutual understanding or arrangement between parties regarding their rights and obligations. So any agreement has to be made between the two parties, or by minimum of two parties have to agree for the same thing, then only they can enter into obligation or rights, right? So that is why agreement is a mutual understanding. First, they need to understand each other terms and have to make an arrangement between the parties regarding the rights. What all rights they will get to know, and what are the obligations they will have if they are entering into that kind of agreement. While all contracts are agreements, not all agreements qualify as contracts, since they may lack enforceability. As I said you, this is the most important requirement of any contract, that all the agreements, not all agreements qualify as contracts, since they may lack enforceability. All agreements may not be the contracts, because some agreements, they do not have the legal enforceability or lawful consideration. For example, I can tell you in the same way that a husband is promising, if a husband is promising his wife to buy a necklace on her birthday. So here you can see that there is an offer by the husband, there is an acceptance by the wife, and so it forms into an agreement. But it can't be termed as a contract, because what is missing here is offer by the husband is there, acceptance by the wife is also there, but legal consideration is missing, or legal enforceability is missing. Legal enforceability is missing. So that's why it cannot be termed as no contract is happening here, but only the agreement is happening. So that's how we can say that it is an agreement but not a contract. So just in order to explain, this can be a good example for understanding what can be an agreement and how is it different from a contract. Coming to the next, differences between contract and agreement. As I said, the primary distinction lies in the enforceability. The contracts are always legally enforceable. That means if the other party is not fulfilling his promise, we can sue him in the court of law. So that is what contract is. A contract is legally binding. That means the party, whoever is promising to fulfill the promise, has to complete it. Otherwise, he will be legally bound to the litigations, right? Whereas an agreement may not be. Contracts require specific elements like consideration. Consideration is something where you will say that consideration definitely means something in return. Consideration here means something in return has to be provided. If I take the before example of visiting a shopping mall where there is an offer and acceptance, when we are providing money, they are going to give us the goods. So that is how something in return can be fulfilled here. So consideration is also a very, very essential element when you are entering into a contract, right? Contracts require specific elements like consideration and capacity. Capacity is nothing but you can't make a contract with any person who is not of the sound mind, or who is not irrational person. We can say that the person should be a rational person. Rational in the sense he should be in his senses. She or he should be in senses when you are making the contract. So that's how that the second element becomes the capacity to contract. While agreements may only require mutual consent to exist. For agreements, it is not an element that is essentially required that the person should be giving something in consideration. Rather, it should not be that the person should be in capacity to contract. So that's how there is a difference between contract and agreement. From each element point of view, we can explain that how Contract differs from the agreement. Agreement requires just the mutual consent between the two parties, whereas contract requires mutual consent, that too in something in written, that is consideration, and also the capacity of the contract. When the person is making the contract, he should be available to make it with a sound mind and rationally, right?